Okay, so welcome everyone to this seminar on AI Regulation and Standardization as part of the Brazil-Sweden Working Group on AI Automation and Digitalization. So today we have the great pleasure to have two separate sessions within this seminar. The first one will be on AI regulation, and the other one is on AI and standardization. In each of these two sessions, we will start with some short presentations to set the scene, and then we will follow up with a panel discussion where we'll also very much welcome comments from the audience. So please post your questions in the chat or question and answering session, and we will bring them up to our speakers. My name is Fredrik Heintz. I'm a professor of computer science here at Linköping University in Sweden, and I'm the Swedish point of contact for this working group, and I will be moderating this first session. And with me, I also have my colleague, Professor Cesar. Maybe you can also introduce yourself.
Hi, my name is Cesar Marcondes. I'm a professor at ITA.
And you will be sharing the second session. So let's go right on to the program. So first, we have a short presentation from Professor Cristina Godoy of University of Sao Paulo, when she will be talking about the current landscape and challenges of AI regulation in Brazil. Please, Cristina.
Hello, everyone. Are you hearing me? It's
Yes.
okay? Okay.
Yes.
First, I would like to thank you, Professor Cesar Marcondes and the organization committee for the invitation to participate in this important seminar that will discuss AI regulation and the standardization. And I'm glad to talk about the current landscape and the challenges of AI regulation in Brazil. So I will share my slides here. Just a second. I'm sharing now the screen. Okay, thank you. So first, we need to present an overview of our regulation here in Brazil in terms of AI. So I will start with the background here in our country. First of all, our main and first action here when we started to talk about regulation of AI was when we have the federal deputy, Eduardo Bismarck, that presented the Bill 21 in 2020 to regulate artificial intelligence here in Brazil. The text does not go deep into the regulation of AI and repeats the OECD principles on AI adopted in May 2019 and the many articles of the General Data Protection Regulation here in Brazil. So it was not a very different regulation. But in 2021, the Ministry of Science, Technology and Innovation here in Brazil presented the Brazilian strategy of artificial intelligence to guide the states in the promotion of initiatives that foster research, innovation, and development of responsible AI solutions. The main problem of the Brazilian strategy of AI is the lack of action to put into practice this strategy. In addition, we do not have a budget to execute all targets pointed out in the strategy. In December 2022, a jurist committee appointed by the Senate here in Brazil published a report with more than 900 pages, which recommends a more detailed regulation of artificial intelligence. And at the beginning of 2023, following this report, Senator Rodrigo Pacheco presented the Bill 2338, which is under intense debate now in Brazil. This bill, Bill 2338, has many connections with the European AI Act, such as the classification of risks. In addition, this bill recommended the existence of an AI authority to issue specific regulations related to the use of AI in Brazil. And some regulatory agencies and the ministries here, such as the Telecommunication National Agency, so-called here in Brazil, Anatel, National Data Protection Authority, ANPD, and the Ministry of Management and Innovation in Public Sectors, MDGI, are showing their intention to incorporate this function and exercise all the tasks mentioned in this Bill 2338. Then now, in April of 2024, Senator Eduardo Gomes issued his report about this bill, as he was the rapporteur of the Internal Temporary Commission on Artificial Intelligence in Brazil. The rapporteur presented a new text to replace the Bill 2338. The substitutive text presented by the Senator Eduardo Gomes is under discussion now and is the subject of many criticism because there is no debate among civil society and stakeholders to introduce substantial changes in Bill 2338. So, let me go here. So we have other two bills that are important when we are discussing the regulation of artificial intelligence. Bill 425 and the Bill 3592. They are presented in 2023, and the Bill 3592 regulates the use of images and the sounds of dead people recreated by AI to protect their the dignity and the privacy of the memory of people who are dead. But the most important is the Bill 4025 that regulates the copyright protection of alive and dead people connected with the content generated by AI. We can point out two critical aspects of this small, because it's a very short bill. And the first one is all content outcomes generated by AI will not have copyright protection despite the level of autonomy of AI systems. Second, all content on the internet will need formal authorization from the author before being used to train AI systems. So the text of these two articles of Bill 425 could negatively impact the development of AI in Brazil, because all content without any specification and exceptions will avoid the practice of web scraping to collect data to train AI systems. And this will not be the solution, because we will import foreign AI systems that will be trained in a way that which is prohibited here in Brazil. So finally, the judiciary power here in Brazil, and I conduct research in the judiciary power in the state of São Paulo, is facing AI problems. We have here in Brazil, in the Court of Appeal of the state of São Paulo, more than 6,000 cases now related to artificial intelligence. And they are solving by our current regulation, such as General Data Protection, Internet Civil Action, Act that was before the General Data Protection, Software Intellectual Property, Technology Innovation Law, Copyright Law, Civil Code, and the Consumer Rights Code. So let's analyze now the Brazilian strategy of artificial intelligence to understand better how an AI Act could impact our national strategy of AI, and how the strategy of AI is important to regulate and know how to regulate artificial intelligence. So this is the focus of my presentation now. First of all, I wanted to talk a little bit about a study that was conducted by the Federal Court of Accounts. So Our Federal Court of Accounts is responsible for overseeing the budget and the financial execution of the country and contributing to the improvement of public administration for the benefit of society. On account of its competence to contribute to the improvement of public administration, the Federal Court of Accounts analyzed the use of artificial intelligence in federal public administration to understand the main AI technologies that are being used by government, evaluate the current stage of use of AI by the public sector, identify the relevant risks related to decisions required by the public agents to supervise the use of AI, and evaluate the level of implementation of our AI strategy. So in the Federal Court of Accounts report about our national strategy of AI, we can see the following results. First, our national strategy objectives are not specific, realistic, and delimited in time frame. Second, the lack of explanation of the initial reference stage and the definition of indicators and the targets to support the evaluation of our national strategy performance and the results. Formal flaws in the presentation of the logical model and how our national strategy focus on problems and opportunities, projecting its results and the long-term impacts. The governance and the management structures necessary to implement the policy are not formally institutionalized in our national strategy, and then our national strategy monitoring and evaluation structure is not formally defined in a standard. So we can identify in these results published by our Federal Court of Accounts that we need to update our strategy and face the problems related to the implementation of it. So the national strategy will undergo review now. It was announced in the beginning of this year by the federal government, and among the possible changes are the merger of some actions that were presented in our national strategy, such as XE4, qualification for a digital future, and XE5, workforce and training. And then also, we are discussing the inclusion of the topic of cybersecurity, in addition to a great focus on XS9, public security. However, it's important to highlight that any publication regulating the topic may also require a review of the strategy also, so they are connected. Considering that the AI regulation will impact our national strategy of AI, we need to analyze the potential risks presented by AI regulation to the Brazilian strategy of AI, such as, the first one is, I will highlight some of these problems and the risks that we have. And the first one that I want to point out is the dependence on technology imports. The level of investments and the regulation in each country will directly influence its position compared to other countries. It's important to strike a balance between regulation and innovation to ensure that the AI is developed and used ethically and responsibly without restriction its progress. As an example of the Brazilian position in the context of AI, it's worth highlighting that the website Hugging Face, the main platform for sharing language models, has around 5 models trained in Portuguese for generating text developed by Brazilians. These models are small, low-risk models with limited capabilities. So they are initiatives to, there are initiatives to train larger models, but they use models trained in English as basis, applying fine-tuning to Portuguese, which also shows the dependence on foreign technology here in Brazil. So added to the underdeveloped market and the lack of structure for the development of AI, the creation of barriers to innovation reinforces the scenario of dependence on foreign technology. This external dependency leads to the flow of money abroad and the increasing production costs of Brazilian products, in addition to concerns associated with data security and the privacy. So furthermore, the greater Brazilians dependence on foreign technologies, the less will be the capacity of Brazilians' laws and the regulations to regulation the development of AI. If Brazilian regulation creates burdens for the exploration of AI in the country, there will be a tendency to export or outsource the training of AI systems, as well as the import of already trained systems, which could benefit from more attractive regulations and the incentives from other countries, and we will not have an inspection structure capable of preventing such AI systems from entering the country. Consequently, excessive national regulation can paradoxically cause the country the loss of its ability to regulate the sector in practice. So here are some objectives of our national strategy of AI that could be affected with, for example, the Bill 2338, such as promote sustained investments in AI, remove barriers to AI innovation, stimulate innovation development of Brazilian AI in the international environment. So the second one, the second risk that I want to highlight here is one of the pillars of AI development is the startups. Although the large companies that lead the race for AI, such as Google and Microsoft, are better now, much of the advancement in technologies due to startups and research laboratories, which OpenAI, DeepMind, and Anthropic are great examples that ended up being incorporated in some way in large companies. In addition to these examples, several AI startups around the world explore different areas, such as health, medicine, security, robotics. Brazil, however, is not a major player in the sector. According to our national strategy issued in 2019, the United States invested $224 million in AI startups, China $45 million, while Brazil invested only $1 million. So this Bill 2338, which seeks to regulate the use of AI, adopts a restrictive nature regarding the development of the AI market, as it emphasizes a reckless aspect regarding the development of the technology in the country, to the detriment of the adoption of guidelines capable of encouraging the responsible development of technology by stimulating the development of research that mitigates the associated risks. In addition, Bill 2338 weakens our national strategy by attributing the management of the strategy to the non-sectoral regulatory body, and by not establishing measures that truly expand the promotion of the area. Bill 2338 creates general governance measures for the development of AI, regardless of the sector and the company size, by establishing the need for controls for high-risk initiatives. One of the effects of this is the possibility that AI systems classified as high risks are developed by large companies with reduced market competitiveness and the loss of innovation capacity. Another problem that I would like to highlight, it's the monopoly or oligopoly enabled by excessive regulation, and the Bill 2338 imposes charges on all sectors that employ AI, adopting more comprehensive measures than those in the proposed European legislation, the European AI Act, as it introduced new requirements and governance measures for all AI agents, regardless of the level of risk, relevance of impact, or benefit generated by adopting the technology. Given this, given this, regulation without due care can burden small companies about smaller companies about large companies in the IT market, implying higher costs of entering the market and starting the development of AI systems, as well as complying with extensive measures of governance, provide an environment where power is concentrated in a few companies capable of complying with legal requirements with the formation of monopolies and the oligopolies to the detriment of a competitive and diversified market. And going to sorry, the last one that I would the last risk that I would like to highlight is the Bill 2338 that deals with copyright in Article 42, establishing exceptions to the use of data mining works in cases involving activities conducted by organizations, research institutions, journalism, museums, archives, and the libraries. But of great impact is our Bill 4025 that regulates the resulting from the use of artificial intelligence. Despite being a proposal with small provisions to change existing laws about concerning copyrights, it has the potential to impact the training and the use of AI systems by providing that, regardless of the degree of autonomy of an artificial intelligence systems, its works do not enjoy copyright protection, with the status of the author being restricted to human beings. So if we use artificial intelligence to improve some work, for example, designers that use artificial intelligence to work in an image, these artists will not have the protection of copyright. So we cannot use in any way, such as it's established in this bill, we cannot use in any way artificial intelligence because then we will not have a copyright protection. And this is also not good. We need to check the level of interference and how human could use to potentialize humans could use to potentialize their work. So this is my final criticism. And going to the conclusion, it's not possible to discuss the regulation of artificial intelligence in a way that it's disconnected from the Brazilian AI strategy, as we must think of a regulatory model that is suitable for achieving the country's strategic objectives. As Brazil does not stand out as a relevant international player, it's necessary to establish a balance between protecting rights and encouraging AI innovation in Brazil. Because of the above, before we move forward in the debate on the approval of a law that aims to regulate AI, we must review our national strategy of artificial intelligence, correct its flaws, establish goals and indicators, and then present a robust bill that can regulate AI without negatively impacting the country's innovation. Nick BR was appointed by the Ministry of Science, Technology and Innovation to create the Brazilian AI Observatory, so-called OBIA, with C4AI, USP, IBM, FAPESP being one of the partners in the initiative that seeks to monitor the use and the risks of AI systems in the country, establish indicators that allow for the best implementation of national strategy of artificial intelligence, point out the best alternatives for the country to achieve the objective outlined in the strategy. I'm now PI at the C4AI and responsible for research related to AI regulation and financing, and based on my research within the Court of Appeal of the State of São Paulo, I was able to identify that the main problem now in the judiciary is the hiring of bank credit by facial recognition. And there is nothing in the bills that mention and regulates this question that we are deciding in our judiciary power. It's why we need to understand our problems before we start this kind of regulation. And of course, we needed to establish our national strategy before pass this bill, such as this 2338 that I presented for you all. So this is all that I wanted to highlight here, and the risks and the problems that we have now when we talk about regulation of AI. These are my contacts here in C4AI, my email. I will be glad to answer any questions. And thank you again.
Thank you very much for that. So we will take questions after our second speaker. So next we have My Bergdahl from Technology Industries of Sweden, who will bring perspectives on Swedish initiatives and regulations. My, please.
Yes, thank you so much. And indeed, thank you to Professor Godot for a very comprehensive presentation of the situation in Brazil. I think, there we go. I'm going to have a short overflying of the what is happening from a Swedish perspective. I'm talking a bit about Swedish initiatives, national initiatives, and then also, as Professor Godot was talking about, the regulation, which is European regulation. And as Fredrik said, my name is My Bergdahl. I'm Director for Digital Trade and Standardization at the Technology Industries of Sweden. It's basically three items I would like to bring your attention to. It's the AI Act, which, as you can see also from the flag there, is a common or joint European regulation. Then we have a national Swedish AI Commission that I'm going to talk to you a bit about. And finally, I'm also going to be describing a bit an initiative that is 5 years old as of today, called AI Sweden, which is a PPP that is focusing on deploying AI in Sweden and enhancing deployment and usage, really. So if we start by the AI Act, indeed, we now, almost now, or just in a few days or a few weeks, we will have an AI regulation in place. It's due to be published sometime in the next few days. So by mid-end of June, it will actually be in force. And it's a regulation on AI systems. So, and the definition of AI system is something I think you might reckon from OECD discussions. It's machine-based, it could have adaptiveness, and the decisions taken or the results of it interferes on how to generate output. It's going to enter into force, as I said, directly when it's published, because it's a regulation, but the effects of it will come into force gradually. So the first part you will see is that we will have a ban on what is called the unacceptable risk, because this is indeed a risk-based regulation. So it's sort of a pyramid format. On the top, you have the AI systems that poses unacceptable risk. And as examples, those are social scoring and manipulative systems. And they will be banned from the European market already within 6 months. So that would be by the beginning of next year or end of this year, depending on actually when we have the publication done. So you see, it's a very short time frame there. They will be banned and will not be allowed to be present at the European market. But then we also have on the next level in the pyramid, so to speak, the high-risk AI systems. And those are a few examples: safety components, and also AI systems that for some reason or in some ways profile individuals. Might be when you are applying for a position or in other systems. And if you run, deploy, or produce or put on the European market an AI system of high risk, and I would also add that those high risk systems are, you could read them out in a quite clearly, not fully clear, but quite clearly in the annex to the regulation. And if you do deploy or put on the market a system with high risk, then there's quite a few obligations that you do have. They are basically, you could say that it's conformity assessment. You need to register the system, you need to have human oversight, you need to have transparency, you need to have technical documentation, you need to show what kind of data that the system has been trained upon, and you need also to make sure that that data is saved so it could be looked upon later on. And of course, you do have to have measures for cybersecurity. It's not detailed as to what you will have to do, but that will be something that is developed later on in standards. And I believe my colleagues from RISE will probably dwell into it on the second hour when you talk about standardization on AI more specifically. If this AI system is considered to be of limited risk, which we think is the vast majority of all AI systems that will be in use, then there is basically just transparency requirements. So it's not at all difficult to fulfill if you have a limited risk, or it's also possible that you will have an AI system that is seen to be of no risk at all, then you have no requirements, of course. To have this work in Europe as a whole, the regulation has put up two entities, I would say. First, it's an AI office. It's an entity within the European Commission that is going to be overlooking and assist member states and also the Commission on how this is being developed throughout Europe. Then additionally, there is an entity called the AI Board that's going to be consisting of members from each member state, and also personnel from the AI office and other stakeholders that will be sitting there in the board, helping each other and taking some decisions ahead. I just wanted to make it clear also that Professor Benoit was talking about the Brazilian legislation having strict regulations on copyright and perhaps also privacy. I just wanted to indicate that those are not within the scope of the AI regulation of Europe. We do have other regulations there that sort of follows, that is also applicable when it comes to AI. So copyright is also applicable on AI, and that goes also for privacy or GDPR issues. When we come to the more national perspective, the Swedish national perspective, it was just not so long ago that a year ago that the government decided to put a commission in place. And the task of the commission is nothing less than to answer the question on how artificial intelligence could bolster Swedish welfare and competitiveness. So you see, it's a huge task for them. The members of this commission, I would say, is mainly high-profile people from industry, and it's led actually by the former CEO of Ericsson, who is also the chair of the board of Volvo. There's a lot of high-profile people in this commission. And what is really interesting, which is not very common, I would say, is that they just recently, a bit more than a week ago, they announced that they are actually going to be putting their final report much earlier than the government requested. So almost 8 months in advance, they're going to be publishing their final report. And the simple reason for that is that they say that Sweden can't wait. As I think we heard from others, from Professor Godon as well, a lot is happening, and we simply don't have the time to waste and sit wondering what should we be doing to try to make effect of AI as much as possible. So it's going to be really interesting to see what this commission reports to the government. They've been very active. They've been talking to all sorts of stakeholders, and I think they've had meetings with basically everyone, and they've been traveling around the country as well to try to get some good ideas on what could be done. And as we do have an EU regulation, it's not going to be on the regulatory side. It's going to be other initiatives. Are there PPPs that could be put in place? Are there educational structures that need to be in place? Are there tax incentives that should be in place for companies? Or how do we make sure that public sector is using the benefits of AI for the good of the population? So it's going to be really interesting to see what they come up with, and that's going to be already this autumn. Finally, AI Sweden, which is a national center for applied AI. I mean, it's been in office already 5 years now. It's quite incredible when you think about it. So it started before the European Commission came up with their proposal, and it came already just a year after we had a national policy on AI. So 5 years ago, this was set up, and it's a PPP. So it's funded both by the government and also by private stakeholders and companies. And there are more than 130 partners today. They run different programs of national interest to increase the usage of AI throughout Sweden. What I find very interesting is that they have just recently been awarded with a task to develop language models for all of Europe. And they've been given this task together with the German colleagues in Fraunhofer. So I think that is one of the key. We know that AI and general purpose AI is very good at English, but not at the smaller languages, which of course Swedish is a very small language. If you're interested to find out more about AI Sweden, which I think is a very interesting structure, you could find it following this website that I put down there. And it's, as you see, they have quite a lot of information also in English. Just to summarize, I think there is a growing awareness of the importance and possibilities that AI brings, both in Sweden and in Europe and globally. And I think from the Swedish perspective, there has been lots of attention lately, and there's been different initiatives from different actors, from different authorities, from different private companies, and from different organizations. But so far, we have seen no clear steering. You know, we are going to have the regulation, of course, and we're going to set up AI regulatory sandboxes, which is a requirement also from the regulation. But I think from the policy side and from the government side, we still would like to see some more clear steering, or at least common goal ahead. So I think next year, 2025, is going to be a very important year. We will then have the report from the AI Commission. We will have the AI regulation in place, even though it will be fully fledged in force only from 2 years after the publication. So that would be mid of 2026. But I think still we will see a lot happening in 2025. And that's all I would like to tell you, just to give an overflight of the situation. Thank you.
Thank you very much for that very comprehensive and clear presentation. So now we have time for questions. So maybe we can have both the speakers and myself on the screen. I cannot see any questions from the audience yet, but if you have any questions from the audience, please just write them in the questions and we will bring them up. But I want to start off. Professor Christina, I'm very curious about this. You mentioned the copyright regulation and so on, and I wonder how does that apply to foreign models? So, I mean, in Europe, there's this that it doesn't matter where it has been developed. If you're putting it on the market, then you have to live up to regulation. What is the plans for Brazil?
It's a good question. Here in Brazil, it's the same. If this bill pass, of course, all foreign technology will need to comply with our requirements in terms of training. But what's the problem? We don't have a structure to check what is entering here in Brazil. So this legislation will not be effective here. We will not have this this legislation will not have its force, and this is the main problem, because how we will fiscalize and check what is entering, what people are using? This will be very hard. So companies here in Brazil, startups, will need to comply, because then they are under the government eye. But technologies that will enter, and we know that it's easy here in Brazil, we will do nothing. This is the problem. It's why I think that it's not a good approach.
So, but then who? Yeah, please, me.
May I put a question later on for Professor Godoy, please, Fredrik?
No, please, you can go ahead.
Okay, thank you. That's really interesting. I was just wondering, with the Brazilian law, do you have any specific authority that will be following the regulation, and is that a specific AI authority, or is it, you know, the responsibility split into different authorities, or how does it work?
In the Bill 2338 that was presented last year, there is an article that says we will have an AI authority here in Brazil that will regulate everything. But there are some agencies, like the Data Protection Authority that we have here in Brazil, that are showing their interest to do this this whole also. So this is a problem also, because maybe we will not have an AI, a specific AI authority, but we will have another agency that will do both roles. For example, data protection and the AI questions. And they are connected, of course, but they are not the same. So this is also one thing that we are very scared about this project.
So we have a question from the audience, so from Professor Carlos Ribeira from ITA, which actually relates to this general data protection law. And his question is, how does this data protection law harmonize with the proposal for a separate copyright law for AI? And actually, I think that question goes equally well to me from the kind of Swedish-European perspective, but let's start with the Brazilian perspective.
Yes, there were a lot of criticisms when we passed the general data protection law here, because we didn't harmonize with the copyright legislation here, and we lost the opportunity. And between then, we have more than 30 years of difference between the general protection, the copyright legislation here in Brazil. So we criticized this. And in the general data protection, we do not have any issue related to the copyright protection, okay? So we don't talk about this, but in the Bill 2338 of artificial intelligence, and the other one, the specific copyright legislation on AI that I presented in the 4035, both want to regulate the copyright applied in AI systems. So they want to impose some restrictions when we are talking about the generation of content by AI. So what we have now, we have some judicial decisions here in Brazil, and our courts are deciding that any content generated by AI are not protected with the copyright. So we didn't enact the bill, but our judiciary is is applying this bill, so this is a problem also here. So we have one problem with a platform of news that they shared a lot of news here in Brazil, and they use some tools, AI tools, to write the news, because they need to publish this fast. And then they issued another platform because they are copying their news. And the judiciary said, no, but this was generated by AI, so there is no problem to copy it. So it's how it works now in this present moment. In the answering about the general data protection, we didn't have this concern when we passed this legislation. So it's why now they want to regulate copyright related with AI system.
So actually one kind of solution or partial solution to this issue that I've heard from a Swedish marketing agency was that they used this kind of generative tools to kind of design the marketing material, but then they hired a human photographer to basically arrange everything according to the generated design and then take a photo, and then they had a person behind the content.
Yeah.
But I guess it's harder maybe with this text example.
Yes, I think that we need to verify the level of human intervention. Because if we work a lot in an image, for example, that was generated by AI, why we will not protect it? Because there is work there. So it's my opinion here, but I am a minority here.
I think one of the most interesting comments I've heard about AI is someone saying that I think we all made a mistake by calling it artificial intelligence. We should have called it augmented intelligence, because it really increases the intelligence of the one using the system. It's sort of, you could do things easier or quicker, and that goes along what you've was just saying on copyright, because if you use AI to create something, that would in essence be something that is better than you could do yourself, but it has been done by you with some sort of augmented intelligence.
Yes, exactly.
I found it very interesting.
So maybe you want to comment on the Swedish situation with
yes, exactly. This was my question.
I
how
think
it works in Sweden.
No, I think also, when it comes to privacy and general data protection, I think within the AI regulation, it's clear that the General Data Protection Board has a role to play, and they are part of the AI board. But I think it's also clear that AI Act is not the same as GDPR, and AI is something that enables also competitiveness and growth. It's not a vehicle for just protecting privacy, because then we wouldn't have needed a specific AI regulation. That would have been a part of the GDPR. So I think of course there are aspects of copyright, there are aspects of privacy, there are aspects of different sorts, but AI in itself is much wider. So I think that is the reason why we should have this framework regulation, horizontal AI regulation, as we now do. And then we should the General Data Protection Authorities, they are the ones that are dealing with privacy and data protection. And if there is a situation within an AI application or AI deployment that involves privacy, of course they will play a role there. But I am very much against putting, now I forgot the English word, but say that AI is the same as GDPR, because it's not. It's much wider, and it applies particularly, as I'm from the industry side, I think, to our members, companies' possibilities to increase, innovate, and develop new innovative solutions, services, and products. I think that's a very important tool for them as well. So that's why I think, obviously the GDPRs of this world, they are They have a very, very important task to do, but it's not, AI is not only GDPR. It's much wider than that.
Thank you. So we've gotten some another question here from Renato Rodriguez. So do you then, and that's directed to Professor Christina, do you think that the Brazilian government will follow Europe in terms of laws and legislation, or will it try to do something new as it seems to happen already?
The way that I'm checking how we can follow the discussion, we will follow European Union, and we will be more restrictive than a European Union, because of course we have the classification of risks of AI, but there are some requirements that we will apply in any sector, and will not depend on the classification of a risk. So we will put a lot of barriers that we don't check, for example, in the European AI Act. So I think that we will follow European Union, and we will do more if we we continue to discuss in this way. We have a substitutive text for the Bill 2338. It is the substitutive 14 that was presented by our Senator Cesar Marcos Pontes. And he said that all content, images, texts generated by AI needs a reference that was generated by AI, a mark. It's wonderful, but how we will check this? We will enforce this legislation, for example, if it passes. So we need to check what's feasible, and we need to look for Brazilian innovation, what we can do to do better, and to foster innovation, the development of the country. As I said, we are not an international relevant player here in artificial intelligence, so we are not in the first line of this race. So we need to check what we could do in order to have some technology here in Brazil related to artificial intelligence. This is my main concern here.
Thank you. So me, I'm curious. I mean, you basically represent the companies here. So what is your perspective? Is this regulation, is it supporting innovation, or is it raising the thresholds for innovation?
Well, I think it depends on who you talk to, and I think it's been a lot of discussion since the proposal was being presented. It was presented by the Commission in April 2021, I think. So, I mean, it's been 3 years now we've been discussing this regulation. And during this time, actually, general purpose AI or ChatGPT has actually been on everyone's mind. And that happened after the proposal was put on the table. So my guess is there has been a lot of attention and a lot of fear that this is going really to interfere with possibilities for companies to innovate. But maybe I'm sticking out my throat here, but I think, the regulation as it is much better than we at one point in time thought it was going to be. And it seems to have been going quite well. I think, the cumbersome part will be for those that do deploy high-risk AI, because there's going to be all sorts of requirements on them. But when you read the text, you see that a lot of those high-risk cases are perhaps not our member companies that will be. I mean, when they apply AI as a safety component in their production, then they are going to be deploying high-risk AI. And I think that is something that they are quite used to, because, safety requirements are always, quite cumbersome for companies, as they should be. But I guess that for some of the public sector actors that will be wanting to deploy AI, and they find themselves in a high-risk AI, because actually this is, making decisions that affects individuals, it might be a bit cumbersome. So my hope is really that it's not going to be too much of a hurdle for innovation. I think now we do have it in place. I think it would have been much worse if we would have been, struggling to find agreements for years and years, because then it's very unsecure and unstable. No one knows what's going to be finally put on the table. Now we know, and now everyone has to adapt to it, and let's get on with working with it.
So we have another question from the audience here, this time from Professor Cesar, that we all know that there requires a lot of computing infrastructure to train these large models, and that currently that is basically being done through cloud services that may not be within the country. So with this new regulation, will it be allowed to train these models outside of your countries, or do you have to do it within the country? Let's start with Christina.
Yes, it's also a good question, because for example, GDPR, in order to have, for example, international data transfer, we needed to have an agreement and the authorization to do so. For example, Brazil could not receive some types of data here. For example, bank data. We cannot receive here to process and training, for example, a model from European citizens. So this is not possible. Here in Brazil, we do not have now a regulation from our National Protection Authority, National Data Protection Authority, in order to say how we will have this kind of international data transfer. Okay, so we didn't go deep down of this subject. We have in our legislation the forecast of this kind of regulation, but we do not have specific articles that regulate the international transfer. So what we need to do now is to have an agreement, and maybe after our ANPD, our authority here, data protection authority, regulate it, we will check how we should work here with this kind of data. But what I recommend is to, for example, there are some cloud services as Microsoft, Amazon, that you can, for example, rent a machine that it's located here in Brazil. So with sensitive data, it's important to have this data in the country. So this is a good approach. I don't see that Brazil will put a lot of barriers in the use of cloud computing, because our federal government said that we will follow the strategy of cloud first. We are changing everything in the federal government, so if they do so, all the private sector will do also. We don't have, as European Union has, legislation that talk specifically about cloud computing. What we have, it's how can I say, a decree that it's connected with our central bank that regulate the use of cloud computing in banks. This is our we have only one legislation connected with this, and with our banks here, we need to have a high level standard of security, and we need to try to use cloud computing services with that are located, all the machines and the servers here in Brazil. We have some recommendations, but it's not a law here. It's an executive legislation, that was issued by our central bank. It's how it works now. We do not have some constraints as we could see in European Union.
Thank you. So basically our time is up, but I wanted to just give you a chance, each of you, to just very briefly say, I mean, now you've heard a little bit about the, I mean, the two different approaches. So I'm curious from your point of view, what do you see as opportunities for collaboration or areas where maybe there could be potential for doing more work together? So if I start with you.
Yes, thank you so much. And thank you, Christina. This has been really enlightening. I think, we have more in common than you might think. Just listening to you and your description of the situation, it's quite similar to what we have been seeing here. So I think there is a vast room for more, cooperation, and not least to have more exchange of information and experience. I think that is something, if we have those areas and sort of create environment of trust, I think the cooperation will stem from that as well. So thank you so much. It's been really interesting, and I do see a future ahead of this kind of projects.
Thank you.
So Christina, you want to add something to that?
Yes, I agree with me. We have similar points that we could share and develop some research and the exchange of information here. I checked that you also will, in the next year, will issue a plan and a plan of action, and we are trying to establish our plan so we could share our experience. So it was a great pleasure to understand how it works in Sweden. Thank you for the presentation, and I will be glad to continue this contact. It was a great pleasure.
Thank you very much, both of you. I personally think that, I mean, the big challenge, as we all realize, is the operationalization of this, that, I mean, writing the laws is just the beginning.
Yes.
As both of you have mentioned, the really hard part would be both how do we actually, I mean, for those that want to comply with the regulation, how should they do it? But also, how do we deal with those that are trying to avoid complying? And so I think we're just in the beginning here. So with that, I thank you both very much. And now I leave to my colleague, Professor Cesar, to take on the next part of this seminar. Thank you.
Thank you, Professor Fredrik. Thank you for everyone for this first part of AI regulation. Now we'll move on to the next part, issues on AI standardization. I'm going to call Paula Cerdeira from Embraer to have the talk.
Thank you, Professor Cesar. Hello, everyone. Good morning here in Brazil. Good afternoon. Yes, it's a pleasure to be here, so thank you so much. They said to me to be quickly, so we have a lot of things to discuss. It was very interesting, the first part on the regulation of AI. I have here my colleagues with me from ANAC in Brazil, Brazilian National Civil Aviation Agency. Rosenberg is here as well, Diego Palma, and also Rodrigo Magalhães. And also, I think some colleagues from Embraer as well. I think Cristiano Sadocchi and also Fabrício Pontes from Embraer. We all are together on this, let me say, innovation part of the standardization. I'm going to share my screen right now, and I have a few minutes. So I hope you enjoy it. Where is it? Share again. Okay, share. Yes, share. Are you seeing my screen?
Yes.
Thank you. Okay, so let's get started. So who am I? I'm known as Paulo Livio. I have a master's in ITA, so it's a pleasure to also be a PhD candidate in ITA as well. My PhD supervisor is here, so hello, thank you so much for this invitation, Professor Carlos Ribeiro. Also, I'm artificial intelligence research engineer at Embraer. I started there more than 11 years ago. And 5 years ago, I'm the vice chair for this international joint committee, which is SAE 34. So I'm here to talk about, as a Brazilian, so what are the efforts in the AI standardization? It's not only for me in Brazil, it's worldwide. You'll see in my presentation, and I have the pleasure to count with the support of several SMEs in these subjects and very talented people and engineers. And we have the best practices in AI for aviation. In the near future, we hope so. So for Embraer, we have our commercial aviation, our executive jets, the most well-known now eVTOLs, as you see in the media, and also our defense and aerospace. But why it's all related to AI and other technologies? Because AI is something, we have the AI waves for the last decades, let me say that, more than 50 years ago. And now we are promising that AI can help in certain functions. So that's why I decided to start my presentation, bring some of our new and also our proud of our airplanes that we have at Embraer. Embraer is an OEM, like we have several OEMs around the world, like Airbus, Boeing, and others. So we are all working together in this effort for AI standardization efforts, and we have also the authorities, the ANAC, FAA, and EASA authorities that will be compliant in those products embedded in a cockpit and systems. But when we are talking about AI, those videos are public information from Embraer. You can see here the link on YouTube. I'm not opening these videos right now. I just include to you some photos of it. But here it's more or less 2 years ago, we have at Embraer the Verticals program for autonomy, and they were doing some kind of proof of concept. I study as a research for how to integrate some cameras and these, let me say, perception and visual computing for these new eVTOLs, so let me say program. And they were executing like in helicopters, not in airplane, but they included some systems on it, and the investigation is being done for several years right now for AI embedded and how it can be worked. On the right side, you can also see it at Embraer's official website and YouTube. This is 3 years old video. It's certified functions that help pilots for a safe landing, let me say that. It's called ROAS. And they said inside the video that we use artificial intelligence algorithms to on several applications, as all OEMs use it as well in certain complex systems. So I decided to include those videos here just as an example, because this can help more increase safety, and also this can help better efficiency, like in the ESG environment as well, because we are trying to work in a more globally and also a better efficiency and operation aspects. And AI can help on this efficiency as well. Not only AI, but together with several technologies that you already have in control law, for instance, and others, algorithms. The standardization efforts, what I'm talking about right now, is one international joint committee, which I'm very glad to be part of for the last few years. The kickoff meeting was in 2019, but we discussed this together with the authorities for since 2017 or before that. So we're taking years right now. And the committee is organized by 2 international committees, SAE and EuroK, but it's made by several aerospace volunteers, like myself and several. You can see here the list of global contributors, and we have huge, deep discussions for AI embedded inside cockpit and the airborne side, and also for ATM and ANS applications, like in towers for voice communication between the ATC and the pilots and crew, and what are going to be the standards that can help this embedded application inside of those safety critical systems. The first document published was in 2021. It is called AER 6988. Which is statements of concern. But what is the main point of this document is because we have well-established standards and recommendation of practice that all aerospace and authorities follow. This standard of practice. And now, as we know, AI is new in these embedded environment systems and also in these, let me say, safety critical systems. So that's why we are starting this for the last 5 years, this new progress of this new AI standardization. We call it as for development and certification approval of aeronautical safety-related products implementing AI. We know AI is a broader area, and now we are more focused on the sub-branch of machine learning, you can see here. So the group is divided in a few subgroups, trying to address some concerns and challenges in the creation of AI. Here on the right side, I think you can see, we have some our video communication series. It's all open information. At the video 3, we have our authorities speaking, as Rosenberg is here. He's one of the speakers, myself on the second video, and so on. We have Aerok presentation, Christopher and Airbus in the first video. The second video is Fateh from Thales, myself. The third video is Guillaume Sudan with Rosenberg from ENAC. Guillaume is from EASA. And the fourth video is from Mr. Hadek from Collins, and also Dave Redens from AVSI. So it's a summary on what we are doing the last few years. Here's on the right side is just a small image. We are currently going to the draft 6 of this standard, aerospace recommended practices. They already have 2 numbers from the SAE side, sorry for that. 6983 and ED 324 on the European side. But the content will be the same because we are on deep discussion on what are the recommendation of practices of implementing AI in safety critical systems in airborne and ATM ENS domain. As an aeronautical space, just a pictorial view from our view, we know we already have many software inside in the cockpit, and we follow these standards. It's from decades right now. We implement center functions, as I just recall at the beginning example of ROAS. But we know that all these standards are not sufficient anymore because we are the data-driven engineering. So as a machine learning algorithm is basically data-driven solutions, and we are increasing the complexity of a model, and that's when the new ARP is coming to be part of these very complex and the best engineering practice solutions that we follow to be compliant to all of those aspects and maintain the safety aspects. Here on the right side, as I told you, I have my colleagues here with me, and the Q&A, they can support some of the questions. But ANAC, the Brazilian National Civil Aviation Agency, European, also, I'm sure that in Europe you all know, because it was discussed about EU AI Act at the beginning of the seminar. We all know that we have several AI roadmaps in terms of the safety critical, and EASA is one of the publisher of the several concept paper, EASA concept paper for this. And also FAA right now, they are straight to having several seminars like AI assurance and also FAA technical exchange, because this is discussions between the authorities and also the applicant, which is the OEMs like Embraer, Airbus, and so on, because a new standard is built together. And that's why I emphasize here, these 2 international organizations working with several OEMs and suppliers. And we are trying to link and match all of these architecture, which is very known and established in aeronautical perspective. Because the regulation, we follow these procedures, and we want to, and for the currently, let me say, traditional software development, we follow these standards here for systems perspective and IP perspective. But when it's coming to AI and emphasize here machine learning, we believe it's going to be in the middle between those architectures. So that's why we are building this for the last few years. As I said at the beginning, we have like these AI building blocks, and also FAA, they have this technical exchange. It's all public information. You can check all of them. But the main point is how we are going to harmonize. So we have several, just not several, like 3 or 2, let me say, panel discussion between the authorities and our committee in internal meetings, and also in one conference in March this year. But we are trying to harmonize and convergence all the strategies for what we call trustworthy AI building blocks inside of what's going to be this new standard, and what are the challenges as an applicant we are passing through. So I think I finished before my 15 minutes. I hope you could understand, and in Q&A we can discuss more and go into details of it. And I hope if you have time, watch our video series. It's a summary of what we are doing. And one thing to say, we are very proud as Brazilian and to work at Embraer and also have the support of the authorities, Brazilian authorities here. But as I said at the beginning, it's a worldwide challenge. It is not only from Embraer, so that's why we all work together. And that's it from my side. Thank you.
Thank you very much, Paula, for the presentation and the points. I'm going to pass now the speak to Suzanne and Hakan from Rice Research. Please, if you could introduce yourselves. Thank you very much.
Thank you.
Thank you.
You're Suzanne, and I'm Hakan. Do you want to start?
I can start. So we are both from Rice Research Institute of Sweden, where I'm a senior researcher and legal expert. We're researching what the area is policy, AI policy. Maybe you can elaborate on that if you want to. But my background is, before I come here, I worked as a judge and also within the legislative procedures in Sweden.
So I'm the second half of this cross-functional team, and I have a more technical background. I have a PhD in computer science from the University of Gothenburg. When we say policy, we mean anything that tries to influence people to act in a specific way. So it could be law, but it could also be internal corporate policies or a standard. And I will be quiet because I can't multitask, so I'll get the presentation rolling
and I'll say something. That works.
We're in the same room, if you're wondering. That's
good to say that. So we are in the same room. But so if you see us looking above the screen, that's what we're doing, trying to connect. All right. So we'll share some on AI standards in the EU.
And AI standards in the EU all emanate from the AI Act, as me described earlier.
And also Paula mentioned. So yes. And it will enter into force like any day, because we're just waiting for the official journal to publish, and then for the time. And it will be a stepwise introduction in 6 months and 2 years and 3 years.
When it comes to the standards, so the interesting thing with the AI Act is that it's horizontal. So it goes across multiple domains or sectors, or whatever you want to call them. And it has sort of 3 key values, which are health, safety, and fundamental rights. And the ambition is to create trust in AI as technology. So that's important to remember. As we go through the different standards, you will see health, safety, fundamental rights being repeated. It also builds on an existing framework for product safety within the EU. Perhaps you've seen the CE mark, which signifies products you can trust.
So there's the Act says that also AI systems are products. And if they're high-risk AI systems, they need to fit into this framework of product safety. But in this case, there will also be some extra requirements coming out of it being AI systems. So yes, so sometimes it will need CE marking on certain systems, and this also brings in a package of other parts of product safety. So you also have market surveillance authorities that needs to, when you have put your system on the market, there's a post-market monitoring of this. And there will be notified bodies within the conformity assessment processes, sometimes and sometimes not.
Notified bodies are like a third neutral party that come in and say, stamp what you've been doing and give you certificates, so you can claim that you have been doing things in the right way, not only because you are so competent by yourself, but also because this neutral third party has said so.
And then how to reach those new technical requirements, then you can lean on standards, and those are now being developed. And some of them will then be decided and taken on as harmonized European standards. If so, then you can presume compliance if you follow the standards. So that's a key element of those standards that now are being developed. If they will become harmonized standards, then you can lean on them when you implement.
So they will be like the law, the AI Act will be more abstract, and then the harmonized standards will be more descriptive, more detailed in how to do things. So easier to comply with. So basically, if you go through the AI Act, you find there are sort of three bunches of standards. So there is one group of standards for CE marking, and that's targeting systems, sort of safety components for certain domains, like machinery, med tech, toys, elevators, and then also some standalone systems that you can relate to fundamental rights. So for instance, the right to private or public benefits, or
right to education or employment. In that situation, you're not to be discriminated by a system. That's why those need to be CE marked.
And then there will also be standards for the energy and resource efficiency of models and your training of models.
And then there's a last group also that has evolving standards on transparency requirements. And that's for the AI generated content, that it needs to show that this is AI generated. And also if the system is interacting with a natural person, that natural person need to understand that.
They're interacting with an AI system.
Yes.
And there will be some overlap. So if you have a specific system, you need to find out which of these standards are applicable for my system. So it might be all three, or it might be two or one bunch of standards. You have to make that analysis before you carry on. And currently, just this week, CEN and CENELEC, which are two European standardization organizations, are meeting in Bath in the UK to develop these AI standards. So the meeting began this morning. They've been going on since 2022, and they are going to be finished by this time next year, which means that they will have all the standards ready this year so that the standards can go through the formal process of being published. That's at least the timeline they're working on. If that happens, is still an open question.
So, and here we've just listed a few of some of what is going on. It's not extensive, but so that you can get some kind of overview of the standards that are now evolving.
And as you can see, some of them are very going to relate to ongoing work within the ISO IEC community. So risk management, testing of AI systems, cybersecurity, there are already standards there. So why not lean on those initiatives when you do standards for the EU?
And then we'll try to deep dive into one concrete example, just to try to get a grip on, well, what is this then?
What can we expect? So before we do the deep dive, we just go back and say, okay, so there are going to be requirements on AI systems that need to be CE marked. And if you make it very simple, you can say that the conformity assessment process has 2 steps. You need to have everything on board, which shows that you fulfill the technical requirements, which is done by having the right technical documentation in place. There could be additional requirements, but we're keeping it very simple for the time being. So then you have these Article 9 to 15, and you show that you fulfill them in different ways. And then we also have Article 17, which is about the quality management system, and you need to show that you have a quality management system.
And we're going to look deeper into Article 10. One could choose any, but we've chosen the Article 10 and look into data quality then, how to understand that. We had a question on training models, for instance. In that case, you need to try to work with the data quality and the data sets.
So what is data quality and who should care? So going back to the AI Act, I've been talking, so you can have this one.
No worries. But the standard is so in the AI Act, Article 10 then, here there's some kind of definition of what is data quality, and this is training, validation, and testing data sets shall be relevant, sufficiently representative, and to the best extent possible, free of errors and complete in view of the intended purpose. That's what it says. And it says a lot more. And you could just go in and read the article if you wanted in full text. But this is what we wanted to bring forward here. And then, of course, this could mean very much relevant, sufficiently representative, to the best extent possible, free of errors and complete in view of the intended purpose. So we need some kind of, is this fit for purpose? We need some kind of help, and that's where the standards come in.
So we started looking at, this standard is not going to be part of the harmonized standards according to the AI Act, but we think it's a nice way of introducing the topic and reason about data quality. So we'll use this standard first and then move into the other standard, which is being harmonized at the moment. So bear with us.
Oh, yes. So this ISO standard, it introduces 3 ways of looking at quality: syntactic, semantic, and pragmatic.
Yeah. So in the syntactic case, so if you look at this example, you can see there's probably a curly bracket missing, and there might be some weird difficulties when it comes to the key value pairing and so on. But what we're interested in, worth mentioning is that the examples are based on a project we had together with the Swedish Unemployment Office. Might have gotten that translation from the Swedish name wrong. Apologies in that case, but the agency in Sweden responsible for monitoring and helping out when you're unemployed. Semantic quality, so syntactic quality, the well-formedness, semantic quality, how to interpret labels of value. So for instance, date, 01, 02, 03. how to interpret that. Are we talking about the year 2001 or the year 2003? Which month is this? That kind of semantic analysis. And then the pragmatic quality. Is the data fit for purpose? So in this case, we can see that Jane Doe has been applying for course assistant and teacher, and then all of a sudden applies for being a chef. Is chef fit for purpose?
So here so I will have a little bit of extension in order to understand what the agency wanted to do, even though the concrete example that we do want to talk about is data quality. But so the agency has a lot of data on unemployed people and how they look for new jobs because in order to get reimbursement from the government in Sweden, if you're unemployed or arbetslöshetskassan, you have to show that you have applied for new jobs. Otherwise, you won't get reimbursed. So that's the context. And then they wanted to see, can we use all of this data that we have in order to come up with some kind of matchmaking system to help unemployed to find new jobs that are relevant for them. And then from there, we started looking in, well, what are relevant data sets, how to understand data quality, that, yes, free of errors, what's that? And then we looked into this standard. And now let's look into one that might really be a harmonized standard according to AI Act.
Yeah, so 5259 is a series of standards. I think there are 6 of them on data quality for machine learning. And just to keep in mind, data used for training, testing, and validation should be relevant and complete. So let's look at what this standard, which is a candidate for harmonization, actually says about relevance and completeness. So when it comes to completeness, it offers quite a few ways of computing completeness as a ratio. And here's 2 of them. So the ratio of data items of no presence of null data values in a data set. And then there's a question if you count the empty string as null or not. Or the ratio of unlabeled or incompletely labeled samples in a data set. So if we look at our example of job application, we can compute the completeness of this data set based on items such as this job application, which gives us syntactic quality. If we look at relevance, that can be computed as the ratio of features or records in the data set that are relevant to the given context. That's pragmatic quality. That's pretty cool. But it doesn't really help us understanding if Chef is fit for purpose.
Because we still need to know about Jane. We need to know, or John maybe in this case, I don't know. But is Chef the dream job, or is it just the job he applied for to get reimbursed? You need to understand, you need to know what the data stands for.
So there's a lot of talk about knowing the provenance of data and having technical documentation and meta models for data sets, but it might still be really difficult to capture the intention of someone who provided the data. And that's what we need to make an informed decision on the applicability, the fitness of a certain data item.
And then there's also, it's not just one actor that needs to do this, to do that assessment of the data sets they want to use when training or testing or validating an AI model. But there's others, many different actors you need to, and now we've just come up with the ones we see from the AI Act perspective, from actors that AI Act takes on. But of course, as a provider, if you develop the system and you want to provide it to the market, then you need to decide what data to use to train your model with. But there's also, from the notified body's perspective, in the compliance procedure, then if it's a high-risk system that needs a CE marking, you need to interact and understand both of them.
Yeah, so just the notified body, this neutral actor, this actor make the same assessment as you did when it comes to data quality, and do you get your certificate from the notified body or not?
And this is a deployer, because the AI Act also has obligations put on the deployer. For instance, the deployer is to make a fundamental rights impact assessment when using an AI system, high risk. And also, of course, as an authority conducting market surveillance, you also need to look into the quality of the data of a specific AI system that's used on the market or taken into service.
So that brings us to our first takeaway. The data quality implies human judgment.
Yes. From this example.
Yeah.
Yeah.
So even if we have standards, there's still quite a big room for human judgment in deciding if something is good or bad.
And we haven't dwelled into all of the others then. Article 9 on risk management, or on cybersecurity in Article 15, robustness, but at least here.
And then, so what we can see now, if you're looking at a European perspective, is that we have this high-level legal stuff going on, like the AI Act, the Data Act, the Data Governance Act.
Out of them, there will come standardizations. Out of them, you can find.
Yeah, so they're not all of them enforcing CE marking, but they're all of them driving standardization. Yeah, good point. And then if you look at the high-level standards, you can see Senelec working on standards relating to AI and data. But you can also see bodies such as the European Data Innovation Board driving standardization.
And they're not working in a void, in a vacuum somehow, as you've seen in our presentation. Of course, ISO is doing a lot, and ITU, IEC, so there's a lot out there. But from the harmonized standards perspective, it's the ones that Senelec are working on that's central or crucial.
But we also see how people are talking about what they're doing as the de facto standards, trying to operationalize or close the scope of a standard to a specific trade or business or a sector. So for instance, you have the fleet management system standard for vehicles, and 5G for telecom. The top row there, the OASC, GAIA-X, ITSA, and FIWA are all working on different standards in terms of data sharing. So you can see how these de facto standards are also emerging and competing for being the ones who fulfill the higher level standards. And a trend we can see when looking at what's happening with the EU is that the outcomes from projects become either standards or governance models for standards. So EU research projects to become detailed.
Thank you.
That's us.
Thank you very much, Suzanne and Hakan, for your presentation. So let's move to questions and see what we can discuss more about. Please, if anyone has a question from the audience, put it in the question and answer board. I will start with one question related to the ethics. Usually, like if you do social work, you have to go through a ethical committee to do authorization for your, interviews or stuff like that. In the case of these AI systems, they may have some implication how socially it works. So is there something related to that on these standards?
I can start this answer based on SAEG 34 committee, which I'm the vice chair. For this current draft, no, we are considering only machine learning, and we emphasize as a warning that ethical aspects are not considering for the building the construction of the objectives of this standard at this moment. However, we understand that the ethical aspects is going to be a huge impasse in the data-driven systems. Because bias and so on. And EASA on their AI trustworthy building blocks, they included as a separately as ethical aspects as well. And we are aware that there are several research and projects and also some legislation around it. And this is going to be an input for this kind of aeronautical systems embedded as well. But at this moment, no. As the same as cybersecurity, information security, we have different standards that already has in the past several, let me say, recommendation practices and guidance around it. But as I told at the beginning of my presentation, machine learning is a sub-branch of AI. And we know for embedded systems like airborne systems, we already follow several procedures and standards, and but these are some of the concern, of course, I'm sure.
Thanks, Paula. Anything from Suzanne or Hakan?
I'll start and you can follow up. So just as Paula mentioned, it's very a central part is systems that are non-biased, that do not discriminate. So that's one motive, and there's also the fundamental right issues, and that comes out in the legislation in different ways. Where one is that you need to do this fundamental right impact assessment as a deployer. So in that sense, it comes back, and then you have to look into it. How, and then fundamental rights, that's just European lingo for human rights. So when I say that, that's from the EU perspective, then they go to the charter, but it's human rights they talk about. I expect.
So I'm saying something you taught me, since
very good, because I didn't. Yes.
And it's that all laws are always applicable unless something is clearly stated that they're not applicable. So the AI Act as such does not introduce an ethical board. But if there is an ethical board according to another law, that law is probably still in force, because I can't see anything in the AI Act saying it's overriding ethical boards. So then you need to comply with the regulations in that law and that ethical board. So we have these cases, for instance, when it comes to using health data for research purposes. Those laws are still applicable. Then there is specific provisions for using for secondary usage of personal data within what's called regulatory sandboxes, according to the AI Act. That will require that you have a close collaboration with the data protection authority, and that they say that you're doing things in the right way for you to continue that testing and validation of AI. And then since the whole idea behind the AI Act is the product safety framework, you will have the market surveillance authority. So if they suspect anything is wrong, you will have like a reactive ethical board coming in and saying, you can't do it like this. But there's no specific ethical board which is proactive in that terms from the AI Act perspective.
Sometimes we talk about it as the ethical, yes, like there was this high-level expert group on ethics. So they came up and with yeah, and Fredrik was in that. But they sorted out some ethical norms. And of course, those are then translated into the law, which we translate into the standards. So the ethics are supposed to be there in the standards, just as Paula has an example then from the air, embedded systems within air systems. But then if it really goes that way, who knows? That's why EU thinks we need this market surveillance authorities to look into it and keep an eye on it. And of course, there's also liability issues, but also we'll keep an eye on it, because if there's damages, those need to be taken care of. And that also then goes back to ethical damages. It's complex, but sometimes it does fit together.
Yes, thank you. So
an excellent question. You had long answers.
It can be hours debating this, right?
I had this questioning because I'm submitting a project on cybersecurity and AI.
There you go. Okay.
And I was wondering if I had to go through some ethical, and with a partner from UK. So I asked them, and they said only if it needed. So something very similar to what you're saying. All right. Renato Rodriguez has a question to Paula. How do you see the future of AI in aviation compared to automation with human monitoring? Will AI replace the automation used today, or will it be something like a second pilot monitoring all the sensors and ready to take actions if something unusual happens?
This is a very philosophical question as well, and it has a very long answer. But yes, let me try to summarize. The future of AI in aviation, we first see like it will be step by step, right? First, functional assistance to humans, and more going to what EASA said, AI level 2, collaborative and cooperative. And in the future for autonomy, yes, we are not so sure about it. We'd like to say is more advanced automation, let me say that. But it's gonna take a job for a pilot. We are not sure we can say that, because we have several things that are beyond on this strategy. We also know that eVTOLs, you can see the link is posted here. We're going to start with a pilot for the next few years. And sooner, when the technologies be more mature, we can try to be with no pilot operation or remote pilot assistance and so on. These are some vision from several companies, and what can I say from the Embraer perspective, what is public information as well. For commercial aviation, usually we have 2 pilots, and for executive jet, we can have 1 single pilot operation or 2 pilots operation. Depends on the size of the aircraft. But we are listening to our customers there as well, and for several of them, at least in executive jet, because of their type of aviation, they like to be single pilot operation. But when we have this piloting capacitation, for some instance, he's not going well and he faint and something like this, this is a risk in our aviation domain. So we need those kind of systems and these automatic systems and this whole complex environment to be more, let me say, going through advanced automation. We already have many automation based on control laws and several algorithms, the traditional software, let me say that. But when we increase the AI on this complex and very best engineering practices architecture, we are adding more challenge because of the nature of the behavior of the algorithms. And I don't believe that the AI is going to replace human, but it's going to help human. And that's the purpose inside aviation domain. And that's my opinion on it.
We have a comment. So
Yeah,
Sweden has
yeah.
a comment. And so if you look at it from an EU perspective, there's a bit of an uncertainty, at least as I perceive it, because for some systems, the AI Act says you always need human oversight. Sooner or later, you can have how many levels of automation overseeing and other levels of automation all the way down, but somewhere you need a human on the top. At the same time, we have these new AI liability rules that says, well, it's just a product, right? So if the product does something that is bad, it destroys something for you, like loss of data, then the person or the organization who put the product on the market is responsible for reimbursing you. So it's two ways of looking at it at the same time, which perhaps fits within a risk as approach, because you know you can't mitigate the risks to 100%. So somewhere there will be things that didn't work out as expected, and then you pay.
Okay. There is another question from Victor Santana. A question to anyone that knows to talk about how the project GROOT, NVIDIA AI robotics, or other projects that apply AI to robots are seen in the point of view of regulations.
It's a tough question to me. I'm not sure how can I answer that. But what can I say in terms of the hardware inside of airplanes? We are passing through several proof of concept that I said at the beginning, because when we have software that it will be running inside an airplane, we have this tool qualification. The hardware must be also following some procedures and also some standards to be complying with, because it's one thing when you are training a model inside of cloud applications or on-premise and in computer, but when you are, let me say, when you are putting this inside of airplane and a target, it's completely different. And for sure, NVIDIA and also several suppliers are aware of those challenges inside of AI embedded for aviation. And yes, several proof of concept are being done and several papers are being published for the last few years, which is passing through what are those challenges inside, for instance, FPGAs, or when we are running a neural network and for computer vision and so on inside of aircrafts.
I think from an EU perspective, you need to distinguish between what kind of robot it is. Because if it's a robot which fulfills, which is within the scope of type approval of vehicles, or if it fits within the civil aviation industry, that's sort of mostly excluded from the AI Act. But if it's a robot that fits within machinery or upcoming machinery regulation, for instance, then you could have the machinery regulation, and you could have perhaps radio equipment on it. And then you would have perhaps also electronics that in an explosive environment. And you can have a number of different regulations that you need to fulfill at the same time. And on top of that, you would also have the AI Act. If you have an AI-based safety component on your machinery, which has radio devices, and perhaps it's also data sharing, so you need to comply with the Data Act and so on.
And then you can do the conformity assessment as hopefully as one from the product view instead of the regulation view. And that's a good example of that it's horizontal. And then they call it sectorial legislation then if it's exempt, but that's a whole area in itself of regulations, for instance, in aviation then, or for shipping, that's another UN regulation, for instance.
But you need to know what goes where, because just because it's on a vehicle or in a vehicle doesn't mean it's part of the type approval of a vehicle. So it could be an EU regulated thing, even if it's in a vehicle. So you really need to know where your systems and your regulations boundaries, how they interact with each other and overlap.
So robotics is very, it's huge. And intersections then is very, very interesting.
Definitely.
Yes.
That's why robots are cool. Not because they do cool stuff, because all the regulations fit in them. And you get all these standards. Whoa!
All right.
All right.
We're getting to the end of the seminar. So let's have some final wrap up from Paula and from Suzanne and Hakan about this theme, please.
Okay, thanks so much. When Suzanne and Hakan was explaining about CNN, CNELEC, one of other standard as well, and also from ISO, it reminded me of several EASA's presentation as well, because we know this standardization effort is made of several components and several committees, and to me, it's important because we will understand every part of the building block for AI trustworthy. We don't have all the answers, so that's why several teams are working on this. And what can I say for the perspective from myself? It's a challenge in creation in AI embedded system standardization, and I would really thank everyone here who was listening to us, and it was very good discussion, and including the ENAC guys here with me. Thank you so much for the support, because with the authorities from aviation side, we need them. And also my colleagues from Embraer and everyone that I know. So thank you so much, Professor Cesar, and thank you so much all, Fredrik and Professor Carlos and everyone.
I'm closing. Thank you, Paula. And thank you all listeners. Some closing might be that I think standardization is really, really interesting right now, because there's technological evolution at the same time as regulatory evolution. And doing this in tandem, it's, yes, we need everyone who can contribute with knowledge here. This is huge. So everyone is really, really welcome to join and yes, work with us within standardization working groups.
Okay.
Please reach out if you want to get involved, and we'll help you.
All right. Right. Fredrik, do you want to say some final words?
Not more than thank you everyone for participating, and everyone for, both our speakers and our viewers. And of course, thank you for all the questions. I think, my conclusion is that we are just in the beginning. It's easy to think that, now kind of AI has been solved. Now it's just a matter of, implementing it. But actually, I think there is so much left to do, and so much exciting and fascinating work left for us to dig our teeth into. And of course, I really hope that we can do this together. So strengthening the collaboration between Brazil and Sweden, and help each other out in this important endeavor. Thank you.
Thank you. Also from the Brazilian side. And I hope I see you again in some more seminars in the future. Thank you very much.